Good afternoon and welcome to the WebEx session on what has changed in Indian Bankruptcy Code lately and how would investors and debtors be impacted. This session will be presented by my colleagues Vyapak Desai, Alipak Banerjee and Arjun Gupta. Please note that this session will be in listen-only mode and will last for about 60 minutes, out of which the first 30 to 40 minutes will be spent on panel discussion. The remaining time will be available for Q&A. Requesting all participants to be on mute mode for this session. You can post your questions on the chat window while the panel discussion is on. The moderators will queue up the questions for the speakers accordingly. Should you need any assistance during the conference call, you can use the chat window. Do note that this conference is being recorded. I now welcome our session presenters, Mr. Vyapak Desai, Head, Dispute Resolution and Investigation Practice, Alipak Banerjee, Leader, Dispute Resolution and Investigation Practice, Arjun Gupta, Leader, Dispute Resolution and Investigation Practice. Over to you, Mr. Vyapak.
Yeah, thank you. So, good afternoon, everyone, and thanks for joining this presentation. And this is we have been taking this webinar since Monday, every day 3 webinars. So definitely this has been a long week for us, and I'm sure for some of the participants who have joined several other webinars as well. So thank you for supporting us, and this was something which we, always thought may be helpful during this time, and hope we'll continue this for the next week as well. You will receive some updates related to next week's calendar on the webinars as well very, very shortly. So looking forward to that as well. Coming back to the program and the webinar today on the Insolvency and Bankruptcy Code. As one can imagine, while the country and the world was facing some sense of downturn in the economy even before the COVID situation, the COVID situation has only, made that downturn even faster. And we would be seeing a lot of issues which would come up in the business and economy so far as the payment issues are concerned, people taking recourse to the IBC, what can be done, what cannot be done. So we thought it may be a good idea to revisit some of those provisions. More importantly, there are quite a few important amendments which came along this month itself, applicable from December 2019. And then there is always some new jurisprudence in India. So we thought that it may be a good idea to touch upon some of those aspects today. So as some of you may know, NCLT and NCLEC are not functional at this point in time. So basically you cannot go and, file or get your matters heard because most of the courts, including Supreme Court, High Courts and tribunals are closed, except some of those courts are open for very, very urgent matters, and that too on a video conference. And therefore it's not different for NCLT. But the good part is Supreme Court has clarified that the limitation period for such claims, including for filing NCLT applications, would get automatically extended post March 15th. And NCLT has also confirmed via notification the same extension, which means, at least people who have live claims are not, facing any problem because of this lockdown. So the limitation period is safe and you don't have to worry about it. The other amendment which came through was the increase in the threshold, and we'll talk about it little in detail. But now you cannot file an application for IBC up to the threshold of 1 crore, which was earlier 1 lakh. This is also in some sense was an industry demand to safe harbor some of the SME, MSME lenders and debtors because even for smaller claims, people used to resort to IBC to exert pressure rather than anything else. So that amendment has also come through. There is also an announcement or an indication, if I may say so, that even section 7 to 10 of IBC, where you can approach NCLT, may actually get suspended if this situation continues longer than expected. And we may hear something on that soon from the relevant ministries. Yes, this has obviously affected all the approval process, the resolution plans, everything has come to a standstill. And there are some live situations where even plans were almost approved, but are implementation. So we'll touch upon those aspects as well. More importantly, today morning, I think we heard from RBI that there would be an extension for the loan defaults, and a moratorium for 3 months will be granted, which means there is some level of support from the RBI and the other financial institutions to ensure that the business and economy doesn't suffer because of this grave situation. So obviously a lot is happening, but just to get into the main topic quickly, there was a recent amendment in the IBC code, particularly for section 32A. And this was also something which was in offing because after taking over the companies under the IBC, the resolution applicant or the new promoter used to face a lot of problems on the past liabilities related to the actions taken by the company or the promoters related to their past businesses or pending litigations, regulatory actions, and so on and so forth. So there has been a amendment to take care of that situation. So may I request Alipak, if you can give a little background as to why 32A was required, what does it mean now, and how does it help the acquirers in this situation?
Thank you, Vyapak. As you rightly said, there have been series of amendments which have been notified recently in March. And this was earlier promulgated by way of an ordinance in December 2019, and subsequently the amendments have been notified. Now, for the purposes of today's discussion, we will focus it on 32A because that is something very significant. It deals with liability for prior offences. I'll first set out what the amendment is and then maybe discuss one or two cases which was carried out. Now, let's first understand what is the principle that is being achieved by this amendment. So the principle, as you rightly pointed out, Vyapak, is that an incoming investor who is deploying significant amount of money, resources, and time in turning around the corporate debtor should not be punished for offences which the erstwhile management or the promoters prior to or during the process of corporate insolvency resolution may have committed. More particularly, the language of the section provides that the liability of the corporate debtor for an offence prior to or during the corporate insolvency process shall cease, and the corporate debtor shall not be prosecuted for such an offence from the date the resolution plan is approved by the adjudicating authority, that is NCLT. Provided that the resolution plan results in change in management or control of the corporate debtor to a person who is not a promoter or in the management or control of the corporate debtor or a related party of such a person. This basically takes away in situations, this only applies to a situation where there is a new management in its entirety who takes over the corporate debtor. Now further it states that the person against whom the relevant investigating authority, could be enforcement directorate, has, on the basis of material in its possession, reasons to believe that he had abetted or conspired for the commission of the offence and has submitted or filed a report or complaint to the relevant authority or court will also not stand exonerated. Now, the liability will also not stand extinguished for a designated partner under the LLC Act or an officer in default under the Companies Act, and who was in any manner in charge or responsible to the corporate debtor for the conduct of the business or associated with the corporate debtor, and who was directly or indirectly involved in commission of such offences. So to summarize, the new amendment gives a protective layer to the new management who had no role in the previous business and tries to give a shelter from the prosecution or the prosecution which may have been undertaken by the enforcement directorate and so on and so forth. Now, this also applies to the property, which is a part of the resolution plan. It states that no action shall be taken against the property of the corporate debtor, provided it is covered under the resolution plan and approved by the adjudicating authority, and if the plan results in the change in control of the corporate debtor or sale of liquidation assets to a person who was not a promoter or had not abetted or conspired for the commission of the offence. It has been clarified that by taking action against the property, it would also include attachment, seizure, retention, or confiscation of such property. Now, coming to the impact of this amendment on the investor as well as the corporate debtor, it has a very significant impact on the investor. We have seen in the recent past that sometimes investors were not willing to invest in these assets because they feared that there will be prosecution and that can go on for months and years. So that now that fear has been elevated, the idea is that the corporate debtor has to start from the beginning on a new slate. And this principle, this has been affirmed by Supreme Court in the SR judgment as well, which we will come in a minute. Now, as regards the corporate debtor, it will ensure that the business revives. The amendment provides a perfect balance. While it does not exonerate the liability of the promoter or the erstwhile management, it ensures that the new management has a fresh beginning. Now, just to briefly touch upon what led to this amendment, I think the JSW Steel case, which was pending before the NCLAT, now at the time the case was going on. In fact, in December, the ordinance was promulgated. Now, after the resolution plan was approved, the enforcement director filed a petition saying that they would want to take further actions against the new management. At that point in time, both the Ministry of Corporate Affairs, they all submitted that this cannot happen. Now that the resolution has been done, the new management should start from a clean slate. Now, at that point, the NCLT had opined that at the time of approving the resolution plan, the stakeholders always have the right to file objections and to make their point before the NCLT and NCLT. Now, that had not happened. The enforcement directors had not objected at that point in time. So, these objections were belated. There was another case by the Delhi High Court. This was enforcement director versus Axis Bank. Now, that case had ruled in negative, and this was earlier in 2019. They basically hold that the imposition of moratorium under Section 14 of the IBC, that would not impact proceedings against the proceedings under Prevention of Money Laundering Act. That is, nothing would preclude ED from continuing the prosecution under the PMLA, and they can do so even during the imposition of moratorium. So this decision, of course, by way of the amendment, this decision has been to a large extent nullified unless the exceptional circumstances come into the picture. Now, on the role of other statutes and IBC, if I may point out one or two more instances, under criminal offences under the Negotiable Instruments Act, the courts have held that the IBC moratorium is not applicable. They can proceed, whereas under the Arbitration Act, the continuance of the arbitration has been put on hold because of the imposition of moratorium, and only if a litigation is pursued which is beneficial for the corporate debtor, that has been held to be fine. That can continue. So there are different nuances which have evolved in last 2 or 3 years as regards IBC and the other statutes. I think I'll stop at that, and then at a subsequent point, I'll also discuss the SR judgment and the role of various kinds of claims, uncrystallized claims or pending claims, and how does it impact. Maybe I'll touch that in subsequently. Yeah.
Sure. Thanks, Alipak. So in a nutshell, I think this is a great news, at least for the acquirers, so long as their resolution application is, taking care of some of this past or pending litigations or issues related to the company and the past promoters. I think now there is a clear indication that, as stated in the SR judgment, acquirer, pretty much starts afresh without, worrying about the past dues or past issues related to the management and the business. So now switching gears a little bit and coming to Arjun. And I think what has changed since the IBC code came into effect in December 2016 till, now, let's say in almost 3 years' time, there has been a, consistent shift of the role of committee of creditors, or I would say consistent evolution of the role, which got crystallized in the SR judgment and then over a period of time through different amendments. So, Arjun, can you give us a little idea as to what's the role of committee of creditors now in different situations, how they should behave, what is their responsibility, what are their obligations, and, how does it help in a situation where, you are, sitting across restructuring and reviving a company?
Sure. Thank you, Vyapak. So, from the inception of the code, what we have seen is that the committee of creditors has been the focal point of managing the corporate debtor along with the resolution professional. And the committee of creditors obviously provides all the vital inputs and approvals to the resolution professional for taking the important decisions with respect to the resolution process, including formulating the evaluation matrix as per which a prospective resolution applicant has to formulate a resolution plan. An evaluation matrix is basically the weightage which will be provided to each aspect of a resolution plan, which will provide a guidance to prospective applicants as to how they would want to lay emphasis on various aspects. Now, post receiving resolution plans from prospective applicants, the committee of creditors has been negotiating, shortlisting these applicants, and thereafter negotiating with the applicants on various terms and conditions as provided in the resolution plan, and thereafter choosing the successful resolution applicant as well by way of a vote of more than 66% by value as comprised in the committee of creditors. Now, what exactly are the powers of the committee of creditors? What are the decisions that they can take? What are the decisions that they are allowed to take? And to what extent can these decisions being taken by the committee of creditors be reversed or nullified or modified by an adjudicatory authority, whether it be the NCLT or the NCLAT? This precise question was up for determination before the NCLAT in the SR resolution process, and the NCLAT had taken a view that the committee of creditors does not have the ability to take a decision with respect to the terms of the resolution plan as submitted by the applicant, and simply what it has to do is, as per the terms submitted, it has to either approve or disapprove the same, and the approved resolution plan can be submitted to the NCLT for the NCLT's consideration, where the NCLT has to look at whether the committee of creditors has whether the resolution plan is compliant with the provisions of the code and any other provisions of law. This particular pronouncement of the NCLAT was challenged before the Supreme Court, where the Supreme Court reversed the decision of the NCLAT and has now provided a particular definite scope of power for both the committee of creditors as well as the adjudicatory authorities. So what the Supreme Court says is that there is no residual equity jurisdiction provided to the adjudicatory authority to change or modify the decision taken by a committee of creditors in its commercial wisdom. Therefore, there is a very limited scope of judicial review provided to the NCLT and the NCLAT to change or to review the decision taken by the COC. The only aspects that the NCLT can take into account is whether the decision of the COC is compliant with the parameters as provided under the code, and whether there is any violation of the provisions of law, including the code. Now, these parameters are provided under the code, and they are threefold in nature. Essentially, one would be maximization of the assets of the corporate debtor. Two would be ensuring that the corporate debtor is maintained as a going concern. And three is to ensure that the interest of all stakeholders, including that of operational creditors, is balanced by the committee of creditors as well as the resolution plan. Therefore, what we understand is that if there is a particular manner of distribution of resolution proceeds provided in the resolution plan, and that has been negotiated between the applicant and the COC, and the COC has approved a particular manner of distribution, then as long as that distribution is balancing the interest of all stakeholders, the NCLT or the NCLAT will not be able to alter such a manner of distribution and will have to simply approve the same. What would essentially constitute balancing the interest of all stakeholders is something that we will discuss shortly, and I think Alipak will take that up. But to first delve into the question of maximizing the value of assets of the corporate debtor, what does that mean? The Supreme Court has also interpreted that in the cases of Maharashtra Seamless and Accord Lifespec, where they have said that maximizing the assets or the value of the assets of the corporate debtor would not necessarily mean that the value of the resolution proceeds provided by the resolution applicant should match the liquidation value. And while saying this, the Supreme Court has actually made a comment or an observation saying that in these particular cases, although the amount proposed or the amount provided by the resolution applicant was below the liquidation value and hence would prima facie be inequitable in nature, still the NCLT will not be able to take an equitable ground on this particular aspect to reverse the commercial decision taken in the commercial wisdom of the NCLT. Therefore, the sphere of power and the limit of judicial review is very distinctly defined as of now, and the committee of creditors has the upper hand and will also most probably lead to a more expeditious manner of dealing with resolution plans and resolution processes, thereby having a greater impact in ensuring that the processes end within the defined time limit of 330 days.
Sure. Got it, Arjun. And I think we have already started getting quite a few questions. We have a question from Mr. Khan, we have a question from Shivani Singh and Ishan, and we'll definitely deal with them during the course of this webinar. In fact, in relation to the disputed claims, it will get possibly dealt with in the next question, which Alipak will deal with as to how the plan needs to be, returned and approved. But we'll just hold on for a few minutes. We'll cover a couple of more topics and straight away get into the questions which are already posed. So coming back to the flow of the session, and maybe quickly, Alipak, if I can get you in. There has been, a huge debate as to how equal are financial and operational creditors. Are they so equal that everything what happens to them has to be similarly placed, or there can be a difference in terms of how plans deal with these two different categories of creditors? If you can deal with this issue both from law and some of the jurisprudence perspective quickly, then we can move on to some of the other questions.
Sure. So I think the distribution between financial and operational creditors has been a bone of contention for last 18 months to 2 years. And we have seen a series of cases. I think the discussion started with the decision of NCLAT in Binani Cement. In that case, NCLAT basically said that the liability of all creditors who are part of the committee of creditors must also be met in the resolution process. The operational creditors do not sit in COC, but still their interests have to be taken care. And in particular, they said that the court aims to balance the interest of all stakeholders and does not maximize value for financial creditors. And then more importantly, it concluded by saying that the dues of creditors, of operational creditors must get at least similar treatment as compared to that of financial creditors. Now this was affirmed by, this was also affirmed in NCLAT decision in SR as well as in Swiss ribbons as well. Now the SR judgment of the Supreme Court reversed the position. In the SR judgment, the Supreme Court basically held that there remains a very narrow scrutiny which the courts can look into. It depends on the commercial wisdom of the committee of creditors. And it held that financial creditors cannot take priority over operational creditors, and it left the balance on the committee of creditors and their commercial wisdom. But importantly, the Supreme Court has also left one or two windows open. And in particular, I'll explain them. Supreme Court has basically said that it has to be taken into consideration the maximization of the assets, and that the interest of all stakeholders, including the operational creditors, must be taken into consideration while devising a plan. It did not specify what would amount to taking care of interest of all stakeholders. So that clearly leaves a room for further litigation. Now, at this point in time, I would also like to share one of our personal experiences. So we had filed a case before the NCLAT, relying on Binani Cement and a couple of other cases. This was a case which was filed much before the SR judgment. During the proceedings, the SR judgment came in. And we relied on the fact that, and we represented an operational creditor who was given zero interest, zero value, and then we argued that, look, this does not amount to tackling the interest of all stakeholders, and we relied on that paragraph in SR judgment, which basically said that just because the liquidation value is zero, giving nil payment to operational creditor would not mean that interest of all stakeholders have been taken into consideration. So on this narrow premise, we were successful in our appeal, and the resolution plan has now gone back to the committee of creditors for a fresh consideration. So while the legroom is really narrow, but then in a given case, and depending on the facts and circumstances, the operational creditor, if they are given zero payment, they could still litigate. I am hoping that the Supreme Court will clarify this as well, what would amount to taking care of interest of all stakeholders. But till such time that happens, we'll see more litigation around this issue.
Sure. So I think while there has been a seesaw of decisions on what is the stake and level at which operational creditors should be considered similarly situated as financial creditors, looks like it has come to a level where to some extent it has been agreed that financial creditors can be treated little differently than operational creditors, so long as there has been a logic around it and a reasonable reason around it. Of course, the law obviously provides what is the fair value which an operational creditor gets based on the liquidation value, and what would be considered fair or a deemed fair value for that purpose. So I think those things are obviously taken care of in the statute and now with the SR judgment. before going into the next topic that we wanted to delve with, which is in reference to the eligibility of the resolution applicant and Section 29 and the whole jurisprudence and legal aspects around it. Let me take one or two questions which are already on the window, on the chat window, particularly from first one which was from Mr. Khan, and I just read it for the people who may be on audio, which is, do you think a provision for discharge for disputed claims of stakeholders may be made a part of the resolution plan under Section 30, subsection 2, without which a resolution plan cannot be approved? Similar provisions are seen in the regulation for voluntary liquidation. Arjun, do you want to touch upon this question and the follow-up one, and then maybe we can go back to the issue of 29A?
Sure. So just to start off with, I think there is a difference between a voluntary liquidation process and a CIRP process under the first part of the IBC. Under the voluntary liquidation process, even before you start the process, you need to make a declaration, as in the board of directors and shareholders of the debtor company has to make a declaration that it has enough assets to discharge its liabilities. Therefore, the requirement to ensure that all pending litigations against the corporate person has also, there is enough sufficient provision maintained to meet with those contingent liabilities as well. But in case of a resolution process under part 1, the idea is that the corporate debtor might not have enough assets to deal with all the existing liabilities in its totality. And that's why we have a consolidated amount which is provided by the resolution applicant, which is distributed amongst various categories of creditors. And specifically in respect of discharging disputed claims, so we have in our experience seen a lot of resolution plans where there are specific portions or specific segments of the resolution plan which deal with extinguishment of disputed claims, extinguishment of pending adjudication claims, and extinguishment of any known or unknown liabilities against the corporate debtor going forward post approval of the resolution plan. So what we have also seen in the SR judgment is that various claims which were submitted by various creditors with the resolution professional were given a notional value of ₹1 because they were disputed in nature, which essentially initially was treated by the NCLAT in a manner to say that although there is no provision made under this particular resolution plan to satisfy the debts of these disputed claims, still the parties to the dispute shall be at liberty to continue the existing disputes under the relevant provisions of law and before the relevant forums post approval of the resolution plan, and the resolution the corporate debtor will have to defend itself against such prosecutions. However, the Supreme Court has taken a different view of this situation, and it has said that all such disputed claims where adjudication is pending, or any claims which have not been submitted with the resolution professional because they were disputed in nature and therefore can be initiated, or proceedings can be initiated in respect of these claims post approval of the resolution plan, shall stand extinguished. So there is no as of now, we don't see any option for creditors who do not have a crystallized amount which has been admitted and accepted by the resolution professional to get a payment under a resolution plan. If you have a claim which is disputed in nature, then it is most probably not going to receive any payout under a resolution plan unless the terms of the plan looks at providing a payout for such category of creditors as well.
Sure. So basically, I think what Justice Nariman says in this context is that so long as the resolution applicant or the resolution professional has dealt with that claim, even if it says ₹1 for the 100 crore claim which is disputed, so long as it is dealt with it, or it has not been raised in either of those situations, the creditor loses their right to go back and claim that amount after the resolution plan is accepted. What the judgment says is that they want to ensure that there is no uncertainty when the new acquirer comes in, and therefore they want the company to be going to the new acquirer on a clean slate. There is another question, which is, will an arbitration application under Section 34 continue after a moratorium under Section 33 of the IBC after a moratorium has been imposed? Maybe Alipak or Arjun, you want to take that?
Yeah, sure. So I'll just take that. So, yeah, Alipak, if you want to go ahead, please.
Yeah, fine. So I think this issue was dealt with by the Delhi High Court in Power Grid versus Jyoti Structure. In this case, what had happened was there was a successful award in favor of Power Grid, in favor of Jyoti Structure, and subsequently a Section 34 petition was filed challenging the award. So the Delhi High Court, while noting the imposition of moratorium under, and during the challenge proceeding, CIRP was invoked against Jyoti Structures. The Delhi High Court opined that so long as the proceedings are not against the corporate debtor, that may be allowed. But this was again on a narrow aspect of Section 34, since already there was a order, there was an award in their favor. The court said that I can allow Section 34, but then enforcement will not happen. So there will be a bar at that point in time. So this was on a very narrow aspect, but the Delhi High Court did rule on this issue.
Sure. Also, there is a question on whether COVID-19 and force majeure would apply in situation where supply chain breakdowns happen and they are not able to pay the amounts, and whether such a dispute will be valid dispute in terms of Section 56A. I think these are two separate aspects, and maybe if I can take that quickly, and then Arjun, you can come on that as well. That so far as the issue whether this would be a force majeure or not, it's a independent discussion. It would apply to every situation, and it has nothing to do specifically with IBC. And as you know, we have taken one very detailed session on force majeure. This week, Monday, we took it on 23rd at 3 p.m. We would repeat it next week as well on Tuesday, because there are a lot of people who have requested for that session to be repeated. But in short, so long as either your clause allows you to claim such an event as a force majeure, and if there is no such clause, then you fall back under Section 56, where if the performance is impossible, not impractical, then you will be able to claim a force majeure, and we can deal with this little in detail in the other sessions. Whether this would be a valid dispute, I think so long as you have raised the dispute before the demand notice or before the default, as the case may be between financial creditor or an operational creditor, and you have a strong prima facie case on this matter, then definitely it can be raised as one of the dispute if it has been raised in time so far as the operational creditors are concerned. So coming back to the topic and the another specific issue that we wanted to deal with, which is in relation to the who are the eligible creditors and the way Section 29 came up, and it has evolved between different judgments. So Arjun, if you want to deal with the question on force majeure, maybe you can touch upon that and then deal with the issue of creditors.
Sure. So just to add that we have seen that the NCLT and the NCLT has usually taken quite a liberal approach when it comes to interpreting the term dispute with respect to operational creditor applications against a corporate debtor. And they don't simply restrict themselves to what is already provided or the means provided under the code. We have seen cases in which a mere exchange of correspondence between both the parties in respect of the amounts due under a contract has also been treated to mean a dispute. So even in the present case, if a correspondence is initiated by the corporate debtor to the operational creditor in respect of the amounts due under a supply contract or a sale contract, where they bring out the considerations of COVID-19 and the force majeure implications and things like that, which Vyapak just mentioned, then maybe that the same will also be interpreted to mean a valid pre-existing dispute prior to initiation of a demand notice by an operational creditor. So now just coming to section 29A, like Vyapak said. So this will have a few complicated structures, so as to say, in the discussion, but I hope you guys can appreciate what is being said without a blackboard or a diagram in front of you. So 29A basically is a section which deals with the eligibility criteria of resolution applicants in order for them to participate in the bidding process under the code. The reason why this particular section was included in the code was because the government wanted to essentially stop the entities or the people who could possibly be implicated in the downfall or the downgrade of the particular corporate debtor from participating in the same process and taking advantage of the process and maybe getting a huge haircut out of the amounts which are owed to the creditors. And therefore, the eligibility criteria was introduced into the code. Now, the Supreme Court has done a very detailed analysis and interpretation of this particular provision in the SR resolution process, where they have essentially said that this section has to be looked at as a see-through provision, and the de facto position of the resolution applicants has to be looked into rather than a de jure position, which means that you don't need to look at the actual judicial position of the entity or the person who's applying, but you will have to take a holistic view of the factual position, as in if a particular entity has been set up to put a bid, then you will have to look at what exactly is the entity, what are the background, what is the group, what is the other sister concerns, and look at it from that perspective. So the way section 29A starts is it says that any person in its own capacity or jointly or in concert with anybody else participating in the bidding process. So the Supreme Court has said that if we have, wherever particular terms have not been specifically defined under the code, then we will have to look at the Companies Act and the SEBI Act to give meaning to these particular terms. And that's why the term in concert has been looked at from the perspective of the takeover code to mean that if two or more entities are coming together with a common intention and for all practical purposes can be said to be working together, then they would be acting in concert, and jointly obviously would mean the ordinary meaning of the term, which is if two entities are working jointly. So essentially what this means is that if today we are setting up a special purpose vehicle to put in the bid, and this special purpose vehicle is a fresh company and therefore doesn't have any of the does not get hit by any of the eligibility criteria provided under section 29A, then you still need to look at where this entity is getting its financing from, what are the companies which are guaranteeing the financer who's providing this entity with the finance, to ensure that the entire web of companies who are cumulatively involved in putting in this resolution plan are not hit by the eligibility criteria. Now we are going to discuss specifically section 29AC, which says that at the time of submission of the resolution plan, if the resolution applicant is holding a non-performing asset or is in the management, control, or is a promoter of an entity which is holding a non-performing asset, where the NPA classification has been done 1 year prior to the insolvency commencement date, then such a resolution applicant will be deemed to be ineligible to participate in the IBC process. Now, The first part is at the time of submission of the resolution plan. Therefore, this eligibility criteria gets hit only when you are submitting the resolution plan and not before. However, there has been the proviso to this particular subsection will give you a different color to when exactly this eligibility criteria will hit a prospective resolution applicant. But more importantly is the factor of management, control, and promoter. So it is not only the entity which is putting in a resolution plan, but also if that particular entity is in the management, which means if it is the manager, officer, or in the board of directors of a company which holds an NPA, then also the submitting entity or the resolution applicant will be hit by the eligibility criteria. The second is in control, and this in control is not only a de facto control of being able to appoint a majority of the directors of a company which has an NPA, but also an indirect control over the management and policy decisions of such an entity, which means the day-to-day functioning and long-term policies of such a company. However, this control has to be positive control in nature and cannot be in the form of just having rights to block special resolutions or negative control of such an entity. The last is promoter. So it's not just being a promoter as declared in the annual financial results or prospectus of a company, but also being a promoter by way of advising the board of directors of a company which has an NPA to act as per the advice of the resolution applicant, and any other kind of indirect way of controlling an entity would also mean a promoter. Finally, we come to the proviso to this particular section, which says that if a particular resolution applicant would want to would want to cure such ineligibility under this particular section, what should it do? So a resolution applicant has to pay off the non-performing asset that itself controls or some other company controls, which is in the management, control, or promoter of the resolution applicant. And there was a particular argument in the SR resolution process that this particular paying off the NPA should be only if the resolution applicant has put a resolution plan which has been hit by this eligibility criteria. However, the Supreme Court has specifically said that if the resolution applicant is entering into any kind of an arrangement at an antecedent time which is reasonably proximate to the submission of the resolution plan, then even in those cases, the resolution applicant will be hit by this particular eligibility criteria, which essentially means that if the resolution applicant has hived off its interest in an entity, which in turn was holding an NPA prior to the resolution plan, prior to the submission of the resolution plan, but that hiving off was also can be considered to be reasonably proximate to the submission of the resolution plan, still the resolution applicant will be hit by this eligibility criteria. And although it will not be technically holding an NPA, still that NPA will have to be sold off. The relaxation which was provided to this particular eligibility criteria was in the form of an amendment which said that any financial entity as defined under the code, if not a related party of the corporate debtor, will not be hit by this particular eligibility criteria. And by financial entity, we mean any bank, any ARC, any AIF, or any NBFC, or any similar such institution as governed by foreign financial regulators as well. The only other aspect to 29AC is 29AJ, which says that any connected person to the resolution applicant will also be hit by the same disqualification. So and the definition of connected person says that any promoter, manager, or controller of the resolution applicant would mean a connected person. So not only is the eligibility criteria or the disqualification hitting the resolution applicant in a downward way, where anything it controls in the downward stream is hit, but also the promoter, controller, and manager of the resolution applicant from an upward stream perspective is also hit by the same disqualification criteria. subject to the exemption of financial entities.
Sure, Arjun. I think this obviously requires a pretty complicated structure if we try and draw as to who is allowed and who is not allowed. But if there are any follow-up questions on this, we'll be very happy to take up and explain some parts of it a little more in detail. I think there is one more question, and I'll come back to you on preferential treatment little in a while, Arjun. But there is one more question from Mr. Khan, which says, is it the COC who has to decide on eligibility of the prospective resolution applicant under 29A?
Yeah, so just to take that question, Vyapak, so the prospective resolution applicant has to provide a declaration while giving or submitting their resolution plan stating how they are not hit by any of the disqualifications provided under section 29A. This particular declaration is taken into account by the Committee of Creditors and the resolution professional while evaluating the eligibility of prospective resolution applicants. However, if the COC, like we were discussing about the role and the scope of powers of the COC, considering that this is a statutory consideration which has to be mandatorily complied by all prospective resolution applicants, the COC cannot in its commercial wisdom either alter this mandatory requirement or waive it off. So if there is a non-compliance with this mandatory requirement, then the same can be used by the adjudicatory authority to strike down a particular resolution plan as being violative of the provisions of law, including the code, and it can be sent back to the Committee of Creditors for reconsideration.
Sure. Thanks a lot. I think we have already touched upon the questions from Ishan. So, Arjun, one last point for you, and then I'll bring in Alipak for his comments on road ahead, is on preferential transactions and your view as to, how does it interplay in an IBC situation?
Sure. So preferential transactions, what they exactly mean, what is the impact of preferential transactions, what happens if a particular transaction has been classified as a preferential transaction, what is the impact on lenders, and what are the ways in which lenders, investors, or financial institutions have to be careful while providing debt to a company in order to avoid being classified as a preferential transaction. All of these questions have been, to an extent and degree, been dealt with by the Supreme Court in the recent judgment of JP Infrastructure. And what it has done is it has laid down the ingredients of a preferential transaction to mean that if there is a transaction involving the transfer of property or interest in a property by a corporate debtor for the ultimate benefit of one of its creditors, thereby resulting in providing the creditor a beneficial or a preferential position as compared to all the other creditors of the corporate debtor, in case the assets of the corporate debtor were being sold in liquidation and the liquidation proceeds were being distributed under section 53 of the code, then such a transaction can be classified as a preferential transaction if such a transaction has happened between a related party, has happened in the last 2 years prior to the insolvency commencement date, if such a transaction is between a related party and the corporate debtor, and 1 year if it is between the corporate debtor and an unrelated party. Now, to just break this down and to provide a little bit of context to what exactly happens what exactly has happened in this particular circumstance, and why that makes it all the more important for lenders to do an extensive diligence exercise at the time of providing financing to a corporate debtor or to any company which in the future might become a corporate debtor in IBC proceedings, is the manner in which the Supreme Court has read the provision. So, like I said, the transaction which is under scrutiny should be for the ultimate benefit of the creditor of the corporate debtor. Therefore, what the Supreme Court has said is that it is not necessary that the corporate debtor and the lender have a direct creditor-debtor relationship. In this particular circumstance, JP Infrastructure, which is JIL, and JP Associates, which is its parent company JAL, were creditors to each other. As in, JAL had provided certain operational debt in favor of JIL. And JIL, in turn, had provided mortgage or had given its assets as mortgage and security to the lenders of its parent entity JAL. The court has said that although the mortgage is not in favor of JAL, but because the mortgage is in favor of the JAL lenders, thereby providing an ultimate benefit to JAL, therefore, the transaction can be classified as a preferential transaction. Therefore, if we expand this structure further than what it is already there for the JIL and JAL case, if we say that if there is a company A, which is the corporate debtor, and company A has provided a mortgage in favor of the lenders of its parent entity, corporate B, company B, and the money which was given by the lenders of company B was not actually used by company B, but was used by one of its subsidiaries, company C. And company C was in turn a creditor of the corporate debtor, company A. Then we have the same situation where the transaction can be classified as a preferential transaction. Therefore, ultimately, what a lender should do or should consider doing is to add certain provisions in its lending documents, which would ultimately have an end use of funds clause, which will ensure that the entity which is ultimately going to use the funds being disbursed by the lender will not have a creditor-debtor relationship with the third party which is giving security to the lender. The second point, sure, Vyapak.
Sure, thanks, Arjun. And I think the last point that we wanted to cover was on what to expect. Maybe we just have 2-3 minutes to go, but there is a follow-up question, and therefore, Arjun, I told you to deal with that. And the follow-up and the last question on the chat window is: do you think the look-back period be 1 year since persons referred, that is the JAL lenders, are not related to JIL?
That is correct.
Correct.
Yeah.
Okay. So the answer to that question is yes, that is correct. So that also, we have tried to cover most of the questions which are already on the chat window. This is one more, and we still have 2 minutes. We'll cover that. It just came in. Arjun, you may want to deal with this as well. Isn't the transaction between JIL and JAL very common between group companies? Classic example, ILFS and many other group companies.
Yeah, it is definitely common that a subsidiary of an entity would give a security in favor of another entity for the funds which are being given to that entity. And that is why it is all the more important that, because for a particular transaction to be not classified as preferential, there is no requirement of intention or anticipation. Therefore, lenders have to be doubly sure, and the judgment specifically refers to the importance of diligence of not just the company which is acquiring the finance from the lender, but also the security providing company, and also to ensure that the third party which is providing the security is not merely providing security, but also has a guarantor or a surety relationship with the lender, failing which the lender will not be classified as a financial creditor of the security providing entity, as in the case of JIL. So these are some of the considerations which have to be kept in mind.
Sure. Thanks a lot, Arjun. I hope that answers Komal's question. With that, we are just 1 minute away from ending the session, and all questions are taken care of. So maybe Alipak, you want to give one last point, considering what's happening today. Do you think IBC, the government has done enough, that there is not too much of threat on IBC, but it will be a great forum to allow a lot of acquirers to, take care of the situations which would occur as we go along?
Sure. I think initially, we started, it may have been a bumpy ride, but last couple of years, I think this statute has moved really fast. We have had terrific judgments. The amendments have also kicked in. I think the recent amendments to 32 will only enhance the new investors, and it will give them new enthusiasm to invest, and that will enhance the investment pool in this segment. And also, The timelines have been a bit of a worry. Well, now that the courts are shut, I hope when the situation improves, I think we can do a little better on the timelines, and that will only ensure that the CIRP process is completed as it was initially expected under the statute.
Yeah.
And
sure.
Yeah, and the last word is,
So with that,
the future is fantastic. Yeah.
Sure. With that word of hope, I'm sure IBC will be something which we will be able to use positively to ensure some of the situations which will occur post this downturn are resolved in a way it should be, rather than we lose out on many situations and the opportunities go away. So thanks a lot for everyone to join. We have just concluded the session.